Today I'm going to talk about parental responsibility and what it means, and how that differs from being a parent, because there is a legal and a real distinction between the two. I will also look at who automatically has and the circumstances in which someone can acquire parental responsibility. But first of all, if you're new to my channel, I'm a barrister who helps you understand law, so make sure you hit that subscribe button so you don't miss out on any future videos. So there are a number of people that can have or acquire PR, not just the biological parents. So this would include step-parents and other individuals. So what exactly does PR mean, and how does that differ from being a parent? The important act to understand this is, of course, the Children Act of 1989. Section 3 defines what PR actually is, and it reads as follows. Meaning of parental responsibility. In this act, parental responsibility means all the rights, duties, powers, responsibilities, and authority which by law a parent of a child has in relation to the child and his property. It also includes the rights, powers, and duties which a guardian of the child's estate would have had in relation to the child and his property. So broadly speaking, as you might expect, a person with PR will be making decisions on behalf of the child, predominantly in the areas of accommodation, education, and medical treatment, among others. Section 2 of the Children Act provides the starting point as to who has PR in respect of the children. Under Section 2.1, where the mother and father were married or in a civil partnership with each other at the time of the child's birth, they will each have responsibility for the child. The situation differs slightly where the parents are not married or in a civil partnership with each other at the time of the child's birth. If the child was born on or after the 1st of December 2003, the father can acquire parental responsibility by being registered as the father on the birth certificate. However, registration as the father not only requires the mother's consent, but he must be the father in both fact and law to acquire parental responsibility in this way. So again, the default position is if the mother and the father are not married or in a civil partnership at the time of the child's birth, then only the mother will automatically acquire parental responsibility, although the father can acquire it in some other ways as follows. Firstly, for example, the father could marry the mother afterwards or enter a civil partnership. Then the child would be legitimated under Section 2 of the Legitimacy Act 1976. Although you would, however, need to check that the father is domiciled in England and Wales at the time of the marriage or civil partnership. As an alternative, the mother and father could enter a parental responsibility agreement between each other and file this with the Central Family Court. However, in the absence of an agreement between mother and father, the father may make an application to the court for an order that he has parental responsibility. Similarly, and on the subject of court orders, if the court makes what's known as a child arrangements order, that typically sets out with whom the child is going to live. If the court names the father as the person that the child is going to live with, then the father acquires parental responsibility in this way also. Similarly, if the child arrangements order names the father as a person with whom the child is going to spend time with, as opposed to live with, the court may also deem it appropriate to make an order that he has parental responsibility at the same time. The father would also acquire parental responsibility if he becomes the child's guardian or adopts the child using the formal procedures. Briefly looking at the situation where a child is born by way of fertility treatment, it is possible that the child would have two female parents. In this situation, the woman who carried the child will be treated as the child's mother and will have parental responsibility in the same way as any other mother. And broadly speaking, the rules apply in a very similar way to a second female parent as they do a father, as I've just outlined. As for step parents, there are one or two ways of acquiring parental responsibility. Firstly is if they are married to or in a civil relationship with a parent who currently has parental responsibility and enters a parental agreement and files that with the family court, or obtains an order from the court for parental responsibility. In the alternative, as I mentioned with child arrangements orders, a step-parent can acquire parental responsibility in one of two ways. Either if they are named as the person with whom the child is going to live, the court will automatically make an order for parental responsibility, or if the child arrangements order names the step-parent as a person with whom the child is going to spend time with, again the court may consider making an order for parental responsibility at the same time. But remember, in the latter scenario, it is not automatic and will only continue for as long as the child arrangements order is in place. So as you can see, more than one person can have or acquire parental responsibility, and one person's will not end just because another acquires it. And remember that whilst each person that has parental responsibility can act independently, there are some situations where there is a statutory duty to consult anyone else with parental responsibility before making those decisions. Examples would include taking the child out of the UK if they are under 16, putting the child up for adoption, or changing their surname, to name a few. And this is an area you should certainly take formal legal advice on, because every situation can be different, particularly if you have a child arrangements order in place, because there may be provisions within that order that you need to seek advice on understanding. So generally speaking, when decisions are made on behalf of a child, anyone who has parental responsibility should be consulted, and there should be an agreement. In the absence of an agreement, invariably it's going to end up in court, and the court is going to have to make one of a number of different types of orders. For example, a child arrangements order, as I've already mentioned, a prohibited steps order, or a specific issues order. But I will cover these in greater detail in another video. So as a very brief summary, if mother and father are married or in a civil partnership at the time of the birth of the child, then each will have parental responsibility automatically. However, in the scenario where they are not married, only the mother will automatically have parental responsibility and the father will not. And irrespective of whether the relationship has broken down or not, the mother may consent to register the father as the father on the birth certificate, in which case he will acquire parental responsibility in that way. But remember, this will only apply if the child was born on or after the 1st of December 2003. And in the alternatives, the mother and the father could enter a parental responsibility agreement and file it with the Central Family Court, or, failing all of that, the father could apply to the court for an order for parental responsibility. Or, as I said, perhaps he could acquire it under a child arrangements order, as I set out earlier. So I hope that's been a useful overview, but of course you must seek formal legal advice, and you cannot rely on this video, because I simply cannot cover every possible scenario, and every case turns on its own facts. But also don't forget to join me at Black Belt Secrets. I will be running through some questions in the comments in a little bit more detail over at Black Belt Secrets, and you'll find the link in the description. So in the meantime, thanks for watching, and I'll see you next time.